Well, I think that's a good enough introduction to Colonel Davis. I think if you could bring us up to...
Aaron, is your mic on?
If you can just talk a little bit about your experience and then talk about what you're thinking now and precedent and things like that.
All right. First of all, I want to thank Karen for inviting me. It's nice to be out of Washington. If you've been watching what's been going on there the last few days, I found there's a lot more civility on the streets of New York than there are on the streets of Washington. For me, the fundamental question, well, I think two kind of bedrock questions are, what are the source of the rights the detainees are entitled to? And I think one area where I probably have disagreement with my co-panelists, I don't believe they have constitutional rights. I mean, my view is if your only connection to the Constitution is a desire to destroy it, then you don't get the benefits of the Constitution. I do think they have rights under Common Article 3 of the Geneva Convention. So I think the first question is, what is the basis of the rights that the detainees enjoy? And then a second point that I tried to implement in the time I was there as chief prosecutor, there's a lot of talk about the common article and the common law, and there's an absence, in my view, of common sense. And to me, that was always kind of the touchstone, was what if the shoe was on the other foot? What rules would we accept if it was an American? No matter, how bad they were or how stupid their activity, would we condone it if the shoe was on the other foot? In fact, I was telling Karen, I turned on NPR last week, and I kind of came in the middle of a story. And the first part of what I've heard was that someone was being detained in Cuba without charge and been held for 3 months. And I immediately thought they were talking about the detainees. But it's an American citizen that they were talking about. That we were protesting, that they were holding an American citizen in a Cuban jail without charges. And I was thinking, well, my God, we've been doing that for 8.5 years now. So, my fundamental kind of touchstone was, what if the shoe was on the other foot? I think you have to, and again, I won't try to repeat everything that Josh just said, but I'd kind of look at it as past, present, and future. In the past, the military order that he mentioned that was signed in November of 2001, if you look at the order signed in the Kieran case, if you put the two side by, if President Bush had submitted his order as a law review paper, he would have been accused of plagiarism, because it was essentially taking the old order. It worked for Roosevelt, it'll work again, it'll be fast, it'll be easy, it'll be secret. And I don't know how many times I heard from Jim Haynes and others that, my God, the Nazi saboteurs were captured, prosecuted, and executed in about 50 days. And here we are 5 years later and nobody's gone to trial, so what's the holdup? It ignored the fact that the Geneva Conventions didn't exist in the 1940s, and there was another 60 years of development of the law that was completely ignored. I think you have to remember, too, that Guantanamo Bay, people weren't taken there with a view towards prosecution. They were taken there to be exploited for intelligence purposes. So I think one fundamental distinction that I still, this view about prosecuting in federal court causes me some doubt is that the things, if you look at like the underwear bomber, was immediately taken into FBI custody, advised of his rights. There was chain of custody on the evidence. All those things were lacking in the cases at Guantanamo Bay. There were no rights advisements. There's little, if any, chain of custody. There were some very enhanced interrogation techniques that were employed. A lot of things that I think would cause some real fundamental problems in a trial in federal court. So that's why the Bush administration worked really hard to come up with this unlawful alien enemy combatant designation, some way that could distinguish these guys from prisoners of war. Because if they're POWs under Common Article 3, they're entitled to a court-martial. And if you look at the rules for courts-martial and the federal rules, they're almost identical. So the problems you'd have in federal court, you would have in a court-martial. So they had to be creative and come up with another classification that could get around having to extend those rights. And that's where we came up with this alien unlawful enemy combatants. In the present, I'm extraordinarily disappointed. I thought in January of 2009, they hadn't even taken the bunning down from the inaugural parade when the president signed the order that said we're going to close Guantanamo Bay by January 20th of 2010. Well, that deadline has come and gone, and Guantanamo's still, going full speed. He also, when he campaigned, said that military commissions were defective and deficient, and they weren't suitable, that trial in federal court was the right way to go. Yet he's waffled back and forth on whether we're going to have military commissions or trials in federal court. And to this day, I think Karen may be overly optimistic when she said this has been a topic, 30 times, and it's maybe the last time. I'm not convinced that 8.5 years later we won't still be sitting here trying to figure out how to do this right. But for the present, the Military Commissions Act of 2006, I went over and met with John McCain and Lindsey Graham, and their question to me was, what do you need to get the job done right? And they made some changes to what President Bush had done in the initial military order. I didn't go as far as I would like to have seen, but it was an improvement. I think if you look at the Military Commissions Act of 2009, I was asked to review it. The phrase that came up during the election, lipstick on a pig, is what I would describe as the changes made by the Military Commissions Act of 2009. There's very little substance change. Like I think it gave the administration some top cover to say, hey, look, these are new and improved military commissions, they're not the Bush military commissions. But the changes that were made were superficial. One of the changes was under the old rule, a person the proponent of hearsay, which in most cases was going to be the prosecution, the burden was on the opponent to prove by a preponderance of evidence the statement should not be admitted. Now, under the new rule, the person offering the hearsay statement, most often the government, has to prove by a preponderance of the evidence. So you've shifted the evidentiary standard by 1/100%. And they're touting that as the big improvement of the Military Commissions Act of 2009. If you look at the people running the military commissions, Susan Crawford is the head of the military commission. She was Dick Cheney's inspector general when he was at the Department of Defense. At her retirement from the Court of Appeals for the Armed Forces, the only person she mentioned by name was David Addington, and she's running the military commissions. If you look at the folks, if you get below the level of Eric Holder and Jay Johnson, the folks that are still actually running the process are the same people that were running it when I was there in 2005 to 2007. So in one of the trials, Al Sharby was one of the folks that we had charged. He has a degree in electrical engineering from Emory-Riddle University. And he came in, the judge explained his rights, and the judge said, do you understand your rights? He goes, yeah, same circus, different clown. Well, here we've got the same circus and the same clowns that we've had for the last several years, and there hadn't been any change that I can see. For the future, if I were king and I could do what I wanted, I think one of the points that was mentioned about why we should have public trials, we kind of went it alone in the global war on terrorism. It was our way or the highway, and the Bush administration struck out on their own. I think if we really want to be a part of the global community, terrorism, in my view, is not a domestic issue. I mean, it's an issue that affects everyone around the planet, not just us. Also, another issue, I think, is piracy. It's been an awkward fit. What do we do, with these pirates that don't really fit neatly into domestic law? So I guess if I were king, I think there ought to be an international terrorism tribunal, something similar to the International Criminal Court, to handle these kinds of cases. Now the problem is, we've been at it for 8.5 years and we can't agree domestically on how to handle this. So I think achieving an international consensus would be a bigger problem. There are also proposals for a national security court. It was interesting recently, if you saw Liz Cheney lambasted some of the DOJ attorneys that used to represent detainees. They called them the Al-Qaeda 7. One of those was Neil Katyal, who's now the principal deputy solicitor general, who represented Hamdan at the Supreme Court. And now he's being labeled, tarred and feathered as being part of the Al-Qaeda 7, as if he is on their payroll and adopted their view. Neil is a proponent of national security courts. So if he's on the Al-Qaeda payroll, they ought to get a refund, because that's clearly not what most people, I think, on the other side of the fence would advocate for. And then I guess, if we can't get to that point, this question of military commissions or trial in federal court, again, I go back to, I think the rights that detainees are entitled to are the rights under Common Article 3. And in my view, either a military commission or federal court surpass that standard. But I think the administration needs to pick one and not try to have it both ways. So that's been my real disappointment. In fact, I wrote an article in November where I said the administration ought to, it's double standard justice to say some are going to get the full benefit of federal courts and the others are going to get something less. The 3 Americans that are being held in Iran right now, if the Iranians said we're going to give 2 a full trial and one's going to get something less, I would expect us to object to that. So I don't know how we can condone it when we do it and condemn it when somebody else does something, the same thing that we would have done. Now, I wrote an article about that. I was working for Congress after I retired from the military. I published that article and I got fired for doing it. So I'm now Anthony's client. You know, for a while there, we were kind of, the ACLU and I were kind of on opposite sides of the fence, and now they're my attorneys, and I'm very grateful for them. So thank you for defending me.